School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 4 Legal and Regulatory Framework for Financing and Investments of Business. Unit 8 Foreign Exchange Management and Related Regulations. Part 3.
Authorized person. The authorized persons are the authorized dealers, money changers, offshore banking units, or may be called by any other name, who are authorized on behalf of the RBI to deal in foreign exchange or foreign securities. The RBI shall authorize such person in writing and shall be subjected to the conditions laid down by the RBI. The RBI can also revoke the authorization at any time if the revocation is required to be done in public interest or the authorized dealer fails to comply with the condition subjected to which authorization was granted. However, before revocation, the authorized dealer has to be given a reasonable opportunity of being heard. Duties of authorized person. Number 1. An authorized person shall in all his dealings in foreign exchange or foreign security comply with general or special directions or orders of the Reserve Bank. Without the prior permission of the Reserve Bank, an authorized person shall not engage in any transaction involving any foreign exchange or foreign security which is not in conformity with the terms of his authorization. Number 2. Before undertaking any transaction in foreign exchange on behalf of any person, the authorized person shall require that person to make such declaration and to give such information as will reasonably satisfy him that the transaction will not involve and is not designed for the purpose of any contravention or evasion of the provisions of this Act or of any rule, regulation, notification, direction, or order made thereunder. Where the said person refuses to comply with any such requirement or makes only unsatisfactory compliance therewith, the authorized person shall refuse in writing to undertake the transaction and shall, if he has reason to believe that any such contravention or evasion as aforesaid is contemplated by the person, report the matter to the Reserve Bank. Number 3. The Reserve Bank may give any direction in regard to making of payment or the doing or desist from doing any act relating to foreign exchange or foreign security to the authorized persons. Number 4. The Reserve Bank may also direct any authorized person to furnish such information in such a manner as it deems fit. However, where any authorized person contravenes any direction given by the Reserve Bank under this Act or fails to file any return as directed by the Reserve Bank, the Reserve Bank may, after giving reasonable opportunity of being heard, impose on the authorized person a penalty which may extend to 10,000 rupees and in the case of continuing contravention with an additional penalty which may extend to 2,000 rupees for every day during which such contravention continues. The Reserve Bank also has the power to inspect the authorized persons by authorizing an officer on its behalf for the purpose of Number 1. Verifying the correctness of any statement, information or particulars furnished to the Reserve Bank. Number 2. obtaining any information or particulars which such authorized person has failed to furnish on being called upon to do so. And number 3, securing compliance with the provisions of this Act or of any rules, regulations, directions, or orders made thereunder. Every authorized person is under a duty to produce such books, accounts, and other documents in his custody or power, and to furnish any statement or information relating to the affairs of such persons may be required. Contraventions and penalties. If any person contravenes with the provisions of the Act, rules, regulations, notification, direction, or order thereunder, or contravenes any condition subject to which an authorization is issued by the RBI, the penalties have been provided for under the Act for the same. These penalties are: number 1. Such a person shall upon adjudication be liable to a penalty up to thrice the sum involved in such contravention where such amount is quantifiable, or up to 2 lakh rupees where the amount is not quantifiable and where such contravention is a continuing one. Further penalty which may extend to 5,000 rupees for every day after the first day during which the contravention continues. Number 2. If any person is found to have acquired any foreign exchange, foreign security, or immovable property situated outside India of the aggregate value exceeding the threshold prescribed under the provision to subsection 1 of section 37A, he shall be liable to a penalty up to 3 times the sum involved in such contravention and confiscation of the value equivalent situated in India of the foreign exchange, foreign security, or immovable property. If the adjudicating authority deems fit, he may, after recording the reasons in writing, recommend for the initiation of prosecution. If the Director of Enforcement is satisfied, he may, after recording the reasons in writing, direct prosecution by filing a criminal complaint against the guilty person by an officer not below the rank of Assistant Director. Number 3. In addition to the penalty, such a person shall also be punishable with imprisonment for a term which may extend to 5 years and with fine. The court cannot take cognizance of an offence under section 13 except as on complaint in writing by an officer not below the rank of Assistant Director. Number 4. An adjudicating authority, in addition to any for contravention, may also direct that any currency, security, or any other money or property in respect of which the contravention has taken place shall be confiscated to the central government, and further direct that the foreign exchange holdings, if any, of the persons committing the contraventions or any part thereof shall be brought back into India or shall be retained outside India in accordance with the directions made in this behalf. Enforcement of the order of the AA. Any person who fails to make full payment of the penalty imposed on him under the Act within a period of 90 days from the date on which the notice for payment of such penalty is served on him is liable to civil imprisonment. The adjudicating authority has been vested with the powers of issuing warrant of arrest and detention in these circumstances. They are: number 1. An order for the arrest and detention in civil prison of a defaulter can be made when the adjudicating authority has issued and served a notice upon the defaulter calling upon him to appear before him on the date specified in the notice and to show cause why he should not be committed to the civil prison, and when the adjudicating authority for reasons in writing is satisfied that the defaulter with the object or effect of obstructing the recovery of penalty has, after the issue of notice, dishonestly transferred, concealed, or removed any part of his property, or that the defaulter has or has had since the issuing of notice the means to pay the arrears or some substantial part thereof, and refuses or neglects or has refused or neglected to pay the same. Number 2. A warrant for the arrest of the defaulter may be issued by the adjudicating authority upon satisfaction by affidavit or otherwise that the defaulter is likely to abscond or leave the local limits of the jurisdiction of the adjudicating authority. Number 3. Where appearance is not made pursuant to a notice issued and served, the adjudicating authority may issue a warrant for the arrest of the defaulter. And number 4. A warrant of arrest issued by the adjudicating authority or AA may also be executed by any other adjudicating authority within whose jurisdiction the defaulter may for the time being be found. The provisions that are also needed to complied with are: Number 1. Every arrested person shall be brought before the adjudicating authority or AA as soon as practicable and in any event within the 24 hours of his arrest, exclusive of the time required for the journey, provided that the defaulter shall be released at once if he pays the amount entered in the warrant of arrest as due and the cost of the arrest to the officer arresting him. Number 2. When a defaulter appears before the adjudicating authority, he shall be given an opportunity by the adjudicating authority showing cause why he should not be committed to the civil prison. Number 3. Pending the conclusion of the inquiry, the defaulter can also be detained in the custody of such officer as the adjudicating authority may think fit. He can also be released on his furnishing the security to the satisfaction of the adjudicating authority for his appearance as and when required. Number 4. Upon the conclusion of the inquiry, the adjudicating authority may make an order for the detention of the defaulter in the civil prison and shall, in that event, cause him to be arrested if he is not already under arrest, provided that in order to give a defaulter an opportunity of satisfying the arrears, the adjudicating authority may, before making the order of detention, leave the defaulter in the custody of the officer arresting him or of any other officer for a specified period not exceeding 15 days, or release him on his furnishing security to the satisfaction of the adjudicating authority for his appearance at the expiration of the specified period if the arrears are not satisfied. Number 5. The detention order may be executed at any place in India in the manner provided for the execution of warrant of arrest under the Code of Criminal Procedure 1973. Number 6. The adjudicating authority may, by order in writing, authorize an officer of enforcement not below the rank of Assistant Director to recover any arrears of penalty from any person who fails to make full payment of penalty imposed on him within the period of 90 days from the date on which the notice for payment of such penalty is served on him. Number 7. Any contravention may, on an application made by the person committing such contravention, be compounded within 180 days from the date of receipt of application by the Director of Enforcement or such other officers of the Directorate of Enforcement and officers of the Reserve Bank as may be authorized in this behalf by the central government. Where a contravention is compounded no proceeding or further proceeding shall be initiated or continued against the person committing such contravention under that section in respect of the contravention so compounded. Provision for appeal. The Act provides the provision for appeal in 3 stages. Number 1. Appeal before the Special Director appeals against the order of the adjudicating officer. Number 2. Appeal before the Appellate Tribunal against the order of the Special Director. And number 3. Appeal before the High Court. Appeal to the Special Director appeals. An appeal against the order of the adjudicating authority may be made to the Special Director appeals appointed by the central government. Every appeal should be filed within 45 days from the date on which the copy of the order made by the adjudicating authority is received by the aggrieved person. The Special Director appeals may entertain an appeal after the expiry of the said period of 45 days if he is satisfied that there was sufficient cause for not filing it within that period. Appeal before the Appellate Tribunal. The central government or any person aggrieved by an order made by an adjudicating authority or the Special Director appeals may prefer an appeal to the Appellate Tribunal. Any person appealing against the order of the adjudicating authority or the Special Director appeals levying any penalty is required while filing the appeal to deposit the amount of such penalty with such authority as may be notified by the central government. However, if the Appellate Tribunal is of the opinion that the deposit of such penalty would cause undue hardship to such person, the Appellate Tribunal may dispense with such deposit subject to such conditions as it may deem fit to impose so as to safeguard the realization of penalty. Every appeal before the Appellate Tribunal must be filed within a period of 45 days from the date on which a copy of the order made by the adjudicating authority or the Special Director appeals is received by the aggrieved person or by the central government. The Appellate Tribunal may entertain an appeal after the expiry of the said period of 45 days if it is satisfied that there was sufficient cause for not filing it within that period. Appeal before the High Court. Any person aggrieved by any decision or order of the Appellate Tribunal may file an appeal to the High Court within 60 days from the date of communication of the decision or order of the Appellate Tribunal to him on any question of law arising out of such order. The High Court may allow an appeal after the expiry of the said period for a further period not exceeding 60 days if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allows it to be filed within a further period not exceeding 60 days. Directorate of Enforcement. The Directorate of Enforcement is established under the Act by the central government. The government appoints the director and other officers who are together called the Officers of Enforcement. Powers of Directorate of Enforcement. The powers that are being vested in the Directorate of Enforcement and its officers are: Number 1. Power of search and seizure. The Director of Enforcement and other officers of enforcement not below the rank of an Assistant Director can do investigation of the contraventions under the Act. The central government may also by notification authorize any officer or class of officers in the central government, state government or the Reserve Bank not below the rank of an Under Secretary to the Government of India to investigate any contravention under the Act. The officers are also vested with the like powers which are conferred on income tax authorities under the Income Tax Act 1961. Number 2. Special provisions relating to assets held outside India in contravention of Section 4. If the authorized officer has reason to believe that any foreign exchange, foreign security, or any immovable property situated outside India is suspected to have been held in contravention of Section 4, he may, after recording the reasons in writing, by an order, seize value equivalent situated within India of such foreign exchange, foreign security, or immovable property. No such seizure can be made in case where the aggregate value of such foreign exchange, foreign security, or any immovable property situated outside India is less than the prescribed value. Compounding of offences under FEMA. The Act allows for compounding for contraventions under Section 15 of the Act. However, in this regard, the RBI has issued a master direction on compounding of contraventions under the FEMA 1999. According to the notification issued dated May 3, 2000 and FEMA 20R/2017 RB dated November 7, 2017, the power to compound contraventions has been delegated to the regional offices and sub-offices of the Reserve Bank. In exercise of the powers conferred by Section 46, read with subsection 1 of Section 15 of the Foreign Exchange Management Act 1999, the relevant rules are the Foreign Exchange Compounding Preceding Rules 2000 made by the central government in this behalf. In terms of these rules, the Reserve Bank is empowered to compound contraventions relating to Section 7, 8 and 9 and the third schedule to FEMCAT rules. RBI was empowered to compound all the contraventions of FEMA 1999 except Section 3, Clause A of the Act. The contraventions can be compounded by the RBI where the sum involved in such contravention is number 1. 10 lakh rupees or below by the Assistant General Manager of the Reserve Bank of India. Number 2. More than rupees 10 lakhs but less than rupees 40 lakhs by the Deputy General Manager of Reserve Bank of India. Number 3. Rupees 40 lakhs or more but less than rupees 100 lakhs by the General Manager of Reserve Bank of India. And number 4. Rupees 100 lakhs or more by the Chief General Manager of the Reserve Bank of India. No contravention shall be compounded unless the amount involved in such contravention is quantifiable. Now let's summarize the unit. The objective of formulating the FEMA Act 1999 was to consolidate the laws related to foreign exchange, facilitate the external trade and payments, and to promote the orderly development and maintenance of foreign exchange market in India. It can be said that the central government and the RBI have been able to fulfill the broad objectives of FEMA. FEMA has been a reformative legislation which has also been successful in eliminating the ills of its predecessor.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.